Court is calling 2025 CR 007531, State versus Jesse Emmanuel Garza. Can I have parties announced?
Lauren Espinoza for the state.
Luis Martinez on behalf of Mr. Garza.
And are you Mr. Garza?
Yes, Judge.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge. We reviewed it together.
Court will find that the state is in compliance with discovery. Mr. Garza, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Garza, did you review the court admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
One.
This document,
Yes,
did you
Your Honor.
review that with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
You're charged with terroristic threat. Let me see. Threatening to blow up HEB as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the event?
Yes, Your Honor.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is asking that your punishment be assessed at a $1,000 fine, and they're recommending deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
Been none.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 150 hours community service restitution, no contact with HEB on 108 North Rocio or Sufferino Lopez, Diana Lucera, mental health evaluation and stress education program. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
That's without objection, Judge.
All right, state, have you spoken with the complainants?
Yes, Judge.
All right, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly involuntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Judge, we are, and there's just one matter I need to speak to.
Yes.
Judge, given that, after reviewing the facts with the complainants, given the quality of the case, the state and the defense were able to arrive on this as what we felt was an acceptable resolution for all parties. My client has been on bond, on GPS, without incident for almost a year. For a very long time, he was on full house arrest and wasn't able to earn a living. He's just now in a position where he's getting back on his feet.
Ah, here's the human element. What started as a simple propane dispute escalated into felony charges. Shows you how quickly things spiral when misunderstandings meet legal thresholds. And the state initially considered jail time, but deferred adjudication became the compromise. It's a reminder, in law, context matters, but so does perception. Ever been in a situation where a minor conflict got blown way out of proportion? That's exactly what happened here. Lesson learned the hard way.
The state has no objection to me addressing the fine. I'm asking the court to consider probating all or part of the fine. And I look forward to my client continuing to perform in supervision the way he has in the last year.
All right, so what were your issues? Why did you do this?
So Judge, if I might speak to that. There, obviously, we all agree that no threats were made in person.
Mhm.
There were some allegations that threats were made over the phone.
Mhm.
At some point, obviously, the state took this very seriously. Initially, we were talking about jail time. At some point, after looking at the case, we agreed that a deferred was more appropriate, more in keeping with what happened in this case. My client contends this was a big misunderstanding. His appearance when he showed up the next day caused concern.
What was the misunderstanding?
So I was basically, so, Your Honor, like what I was in full rest. The company has to post signage, proper signage to,
So Mr. Garza was open carrying. He did not believe that the signage at the store complied with what's required by the law. So he did not believe that he was in violation to open carry at the time. Given his conversations with his dissatisfaction with some issues at the store, product he received,
So
he
according
shows up
to
open
the,
carrying, everything kind of went badly there.
all
I
right,
think the court
so
understood
according
that.
to what I've read in the STIPs, and everybody correct me if there is anything wrong in the STIPs. It says that he's upset over some propane tanks.
There was a cut dissatisfaction with a product.
And instead of just going there and saying, hey, your policy is gift cards, I'm not getting a new propane or something else, you're not getting the money back. All you have to do is accept that. And then if you want to go sue somebody for not giving you money back, then that's what you do. But you don't call on the phone and then show up with body armor. I mean, that's what it says in the STIP.
And the idea that him showing up in that obviously caused a great deal of concern.
Mhm.
The police were called out. He was arrested without incident. He made bond and he's been supervised without incident ever since.
Do you have any children?
no, Your Honor.
All right, probation, this is what the court is going to do. It's $1,000 fine. It'd be probated, 6 years deferred adjudication, continued GPS partial for employment only, no employment as a home health care provider or with minors, no possession of body armor. I already know there's no possession of weapons as well, but I want you to understand me clearly. That's why I'm saying no possession of body armor, no possession of weapons. Do you understand?
Yes, Your Honor.
150 hours community service restitution. I'll order the stress education course. Once he's completed that, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. You all do a referral to Veterans Treatment Court. There should be no contact with HEB. You're gonna have to go somewhere else other than an HEB.
And he's been going somewhere else. I think HEB doesn't want him there either, so.
And there's to be no contact with the following persons: Seferino, Lopez, Diane Lucera. And there's to be a mental health evaluation. And a TAP evaluation. Out of custody, follow all recommendations. Regular reporting by Zoom or in person, regular random UAs. Probation, is there anything else? Yes, or with minors.
Yeah.
And there's to be proof of employment within 45 days.
And Judge, he does work, kind of does freelance work, and he's been doing that consistently. The court adjusted his probation, I'm sorry, his bond conditions to allow him to do that.
Yes.
You know, he's been complying with the court's orders and that. So we'd ask that if the court's gonna keep on GPS and be in keeping with what the adjustments were made on the bond conditions.
Oh, yes, he's allowed to work.
Yeah.
All right.
But the hours are a little out of the ordinary and they're not.
Oh, just let
Consistent,
probation know.
And given that he's been on bond since January on GPS, at what point can we reapproach the court to reconsider or to ask for modifications we need on that?
After the holidays.
Easy enough.
All right, is there anything else that you need from the court?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal.
Yes, Your Honor.
All right. And probation, the GPS fees will be waived. All right, thank you.
Thank you, Judge.
And we can go on the record, but what was brought over to the court by Attorney Cobb, the defense is entitled to this. One is the homicide interview. The other is a Coban video with Officer Santiago Vizcama, Officer Redmeyer, crime scene photos, the reports from the San Antonio Fire Department arson report, and statements, 911 calls, radio transmissions, more crime scene photos.
It sounds like all of that has already been turned over in discovery, but we can make sure. We
Yeah.
can double check and make sure it's the same stuff.
So as soon as this client comes out, we'll put it on the record.
There was some internal affairs records.
Yes, there is. I'm gonna get
I'm
to that next.
sorry. You were concluding.
Yeah,
I
you know.
really thought there was more than that.
And there is one disc of that. Do you have can I hold your drive to just put this in? Because there are no statements, it's just records. All right, we're going on the record and I'll call the cause number for the attempted capital murder, which is 2023 CR 11452, State versus Jesus Prado. Could I have parties announce?
Melissa Albin for the state.
And Ernest Acevedo for Mr. Prado.
All right.
And now we're diving into the evidence labyrinth. Multiple discs, police reports, crime scene photos, radio transmissions. This is what legal teams live for. Every file could be a clue or a red herring, and the court meticulously tracks who has what. This is transparency, accountability, and legal thoroughness on full display. If you were Mr. Garza's attorney, which piece of evidence would you scrutinize first? The video? The 911 calls? This is where strategy wins cases.
So a motion was filed by defense counsel. And that was certain records related to an internal affairs investigation. The state's attorney, and when I say state's attorney, it's the city's attorney's office, filed a motion to quash, or either to have me do an in-camera inspection. The court has reviewed all of the DVDs that were submitted to the court. This is what the court is finding. With regards to motion to quash, it will be denied as to the homicide interview with Jesus Prado, which is your client's statement, which you should already have. Disc 2 is a disc that has Officer Nicholas Swain on it. I'm sorry, disc 1 is Officer Santiago
Vizcara.
Vizcama.
Vizcara.
Yes. Okay. And Cindy, that's Vizcarra. Disc 2 is Officers Nicholas Swain. Disc 3 is Officer Reitmeyer, Reitmeyer. And Disc 4 is a CSI video done by C. Garcia, also a Nest video, doorbell video. Disc 5 are crime scene photos. Disc 6, crime scene photos. Disc 7 is audio files, the 911 calls, 911 call log, and radio transmission. Disc 8 are police reports, the fire department's arson report, reports from SAPD, and officer statement. The motion to quash with regards to those items are denied. And if you all could make sure each of you have copies of that. With regards to the internal affairs, let's go off the record for a moment. I'm going to tell you all, just one second. All right, so we can go back on the record. The court did review the AI. It's the disc, it's listed as AI 2023-1947 R and L. After reviewing that, the court is going to grant the motion to quash. Is there anything else?
Boom. Motion to quash granted. That means some evidence is temporarily off the table, but notice the court's caution. It can reconsider if relevance changes. And now, a jury trial is scheduled. The stage is officially set for high-stakes courtroom drama. Every decision from here on out can pivot the case's outcome. Courtroom chess in action. Who makes the first move? The state? The defense? Keep your eyes peeled. This is where strategy matters most.
Not from the state, Your
Not
Honor.
from the defense, Judge.
All right. And as I stated off the record, if for some reason what's on that disc becomes relevant, the court will reconsider whether it should be quashed. But at this time, the court is going to grant the motion to quash. And as the court has previously stated to both parties off the record, the police reports that are on that disc are police reports that all parties already have. And the remaining items that are on that disc are not relevant to this case. All right. And we are scheduled for jury trial on December 8th.
Yes, ma'am.
All right, is there anything else?
Don't believe so.
Not right now.
All right, and we're off the record. And counsel, just remember the jail has a new policy, 72 hours for clothing exchange.
72 hours.
Yes, if you do it within 24 hours, they're not going to accept.
Make sure.
All right, thank you.
Here you go.